It's been long believed that those who enter the law profession are fit and proper, showing characteristics of integrity, reliability and honesty. However, according to constitutional law expert Professor Pierre de Vos, the behavior of some legal professionals may be bringing the profession into disrepute. He joins us to expand further on this. Thank you very much, Prof. Always good to see you. So you write, and I quote, "The questionable conduct of some of the lawyers representing Public Protector Busisiwe Mkhwebane, Judge President John Hlophe and former President Jacob Zuma, to name a few, has elicited harsh criticism and led to calls for our courts to censure the culprits," close quote. What is questionable about the conduct of these examples that you cite in comparison to how they should be conducting themselves?
Yes, so there is a thin line between, obviously, every lawyer is required to defend their client, to do what they can within the bounds of the law and the ethical codes, to act in the best interest of their clients. But the problem is that people with a lot of money, either because the legal fees are paid by the state, they represent themselves, whatever, can use the procedural rules to delay matters indefinitely, so that the actual legal and factual questions are never considered by the court. If they do so in ways in which they invoke legal rules that are clearly wrong, that no court in South Africa is ever going to agree to, I think that is an abuse of the legal process. And it is not good for the administration of justice, although it is, of course, good for the clients who then never have to face the music in a court of law.
You speak of people with a lot of money using procedural rules to delay proceedings. And as you rightfully mentioned, every lawyer must do that which is best for their client, or they feel is best for their client. So is the problem here that, you know, having access to money is the problem as compared to a to-do, for instance, who would not be able to afford legal fees, and so then my case would be bungled?
So that is one of the problems. It's, of course, not just a problem in this case, in these kinds of cases. It's generally a problem in that, especially in the civil courts, it's very difficult for an ordinary person, let alone a poor person, to afford the kind of lawyers that will take a case to the court. So the access to court here is a big problem. But it is so that the rules themselves, they are based on the assumption that there needs to be some procedural protection, because that ultimately will lead to substantive justice. That I don't think is always true. But there is the further problem then that those with deep pockets, because they are funded by others or because they're just very rich, they can buy a kind of justice, if you want to put that in inverted commas, that other people can't. So it is a question that a problem that goes much further beyond the kind of examples that I mentioned in my piece.
So a myriad of problems, but you further write that looking only at judgments reported on by the Southern African Legal Information Institute in the past 6 months, you counted more than a dozen cases in which the Legal Practice Council approached the court to have an attorney suspended or struck off the roll for their unlawful and dishonest behavior. You would think there were no consequences for such behavior, but alas, there are.
Yes, so I think in some respects it's good that these cases exist, because it means that the action is taken by the Legal Practice Council and people are scrubbed from the role. What I found particularly worrying is that in many of these cases, the attorneys who were implicated in wrongdoing, stealing clients' money, not registering, not getting a fidelity certificate, so on, they didn't defend themselves by saying the claims against them are wrong. They used, again, these procedural mechanisms and delaying tactics, blaming the system and so on, so that to avoid any accountability, and that is, it might be permitted, but just because you have a right to do something doesn't mean it is right to do it, and these would be those kind of cases.
What then does the court of public opinion make of these professionals that you have cited as acting questionably?
So I don't know what the court of public opinion must do. I did say also in my piece that this cannot be ascribed to all lawyers. There is, of course, this sort of populist kind of assumption that lawyers are inherently dishonest. Some people say whenever they deal with lawyers, that is wrong. This is not the case. My concern is more about how many people there are that do these kind of things, and the cases that is not before the courts, where lawyers play very close, so very close to the wind in using every kind of trick in the book, not always being completely frank and honest with the court when they defend clients. I think that is bad for the legal system. It's bad for justice. Because the assumption is that you must defend your client and represent your client well, but you shouldn't do so in a way that is not going to assist the court to come to a correct decision based on the correct facts and the correct law.
I beg your pardon. Do we know over the years just how many legal professionals have been struck off the roll?
I tried to find that out. I couldn't. I probably didn't try hard enough, so I don't know how many have been struck off the roll, and I also don't know if there's been an increase in recent years. So it would be interesting to hear from the professional bodies like the Legal Practice Council what the statistics exactly are.
Fair enough. Thank you very much, Prof, for joining us this afternoon. Professor Pierre de Vos, penning an article titled "Questionable, Sometimes Outright Dishonest Conduct by a Handful of Lawyers, a Worrying Trend." You can find it online.